Thank you all for having me. Like she said, my name is Lauren Saboski. I'm a partner with the law firm Fisher Phillips. So our law firm practices exclusively in labor and employment law. All I do all day is help businesses comply with the law. That's what I do. I also get businesses out of trouble sometimes too. But that's what I do. Part of my practice that I really enjoy is this education piece, which is let's learn how to do it right before you get in trouble. So that's what we're here to do today. So some of your faces look familiar. You may have seen me talk on this subject at other chambers. I've been talking on this subject since 2018. That seems like a long time ago when the medicinal use of marijuana became legal. And now here we are, 2022, 2023. So when you drove here today, so I wrote this material. I know what it says, so this is not for my purposes, this is for yours. When you drove here today, what were you thinking? I hope she covers this. You were probably thinking, I hope she's not boring. That's really what you thought. Okay, but after that, what kind of questions are you getting in the workplace? What kind of questions are your employees getting? Because I want to make sure that I answer the questions you came here to get today. Yes?
When I applied for a job, I had to have a hair follicle test.
Okay.
For drugs, obviously. So
Okay.
that would be, how can they test you for drugs when now
Okay.
marijuana is legal?
Okay, we're going to talk about that, so stay tuned.
I run a business incubator for startups, and I have 2 home health companies, and they're a little bit worried because they are in desperate need for labor, and they're wanting to know if this is going to affect them in their hiring efforts.
Okay, good question, and we're going to talk about some strategies on how to address that.
Do I need to update my employee handbook?
Short answer, yes. That's the only direct answer you'll ever get from a lawyer. Yes. All other questions, I will say it depends. That is yes. Anyone else? Okay. I am not one of those presenters in which I say, please hold your questions to the end. Please ask questions as it comes up, or as, if we need clarification on what we're going through, what we're talking about. So before we get into those questions, we kind of have to talk about a little history here. So what we are talking about today is Amendment 3. As we all know, if you didn't, I don't know where you've been since 2018, but in 2018, Amendment 2 passed, which gave qualified patients the legal right to buy, possess, consume, grow marijuana in the state of Missouri with limitations. So what that Amendment 2 did is it legalized the medicinal use of marijuana. I haven't read here, in 2018, the law did not address drug testing in employment at all. Didn't mention it, didn't bring it up, not even there at all. So from 2018, we were left with businesses coming to me saying, what can I do with my policy? Do I have to change anything? In 2018, the answer was, you don't have to change anything. You can keep doing what you've been doing. There's no restrictions on drug testing, no restrictions on what you do with a positive drug test, nothing like that. The law was completely silent. So fast forward, 2022, Amendment 3 added to and amended Section 1 of the Constitution and expanded what the voters passed in 2018. Now, this is a very common misconception that I have heard repeatedly since the law was passed in November. It came into effect December of 2022. So put that in your mind. If you have not made adjustments since December of 2022, there might be some things that we need to talk about, okay? So what I am saying here is in that the law added to. A lot of folks have the conception that the Amendment 3 replaced Amendment 2. Not true. Amendment 2 remained and Amendment 3 added to it, all right? So let's get into what some of those changes are. So some of the key changes. Amendment 3 now addresses drug testing in employment. It now allows for individuals to petition for release from prison. Not all people. Individuals that have marijuana-related convictions, nonviolent marijuana-related convictions. It also allows for the expungement of certain arrests and conviction records of nonviolent marijuana offenses. So this is something that we're starting, the expungement of records, we're starting to see that process work its way through the court system. If you all didn't know this, the wheels of justice turn very slow. So it's going to be a process that there are certain records that are going to be expunged, that people don't have to do anything to have that to have their records expunged in that way. There are also changes in the reporting requirements for applicants with marijuana convictions. We're going to talk about what that means here in just a minute. But what we're talking about there is how many of you have applications that have the question on it, have you been convicted of a crime or a felony? Anyone? Some people? Yes? Okay. If you have that question on your application, first of all, if you have businesses in Kansas City, Missouri proper, KC Mo, not Independence or other locations, if you have businesses in KC Mo, that is an unlawful question. Okay? It is not a permissible question. If you are outside of KC Mo, you can continue to ask that question on your applications. If anyone's heard of the Ban the Box movement, does that sound familiar to anyone? Okay. So what this is talking about, the reporting requirements for the applicants with marijuana convictions. If it is a conviction in which could be expunged, that person is not required to disclose it to you on that application. Okay. And then this is just talking about the 6% sales tax on the retail sale of the product. This is probably the biggest question that I am getting. If marijuana is recreationally legal, if it is legal in the state of Missouri, why are we talking about qualified patients? Is that,
Yes,
y'all are,
I'm a qualified patient.
okay.
So
You don't have to disclose. You don't have to disclose. But the reason that we're talking about that is that the law now has two categories of users. All right? And now that we have two categories of users, there's two different sets of rules. Ooh, isn't that risque? Okay? So I pulled this off of the internet. I was searching for something. If anyone looked at my search history after I do these presentations, like they think I just read about marijuana and cannabis all the time. But anyway, this popped up as an ad, and I took a snip of it. But it says, Missouri Medical Green Card. Laws have changed, but recreational users are vulnerable. Stay protected with a green card. A green card protects your employment. Apply now and eliminate the risk of unemployment. Okay? This was an ad that popped up. But the reason that this is popping up is that the law has certain protections now for a qualified patient that did not previously exist. Recreational marijuana users, or your adult use, however you want to refer to it, recreational adult, the Missouri law actually calls it personal use, but other states call it adult or recreational. Those types of users have no employment protections. All right? So these are the terminology that you need to understand. Medical use, we're talking about qualified patients. That's the law. That's the terminology that's used in the law. Personal use, they're calling it a consumer under the law. So we have two different types of users, two sets of rules. Whoops. This is talking about if you're interested in just the quantities that people can possess and sales tax on certain things. One of the things that you'll notice here is a difference in the sales tax rate, 4% versus 6%, and then there's additional taxes that may be added on depending on which location people are selling. So there are differences in the qualified patient who can have 6 ounces. Recreational user can only purchase up to 3. So there are differences in that regard. That doesn't really relate to employment, but some people are just interested in what that looks like. So one of the things that employers continuously come to me and say, now that it's recreationally legal, that means as a business, I can't do anything. Everybody's gonna be high all the time. Everybody's gonna be smoking at work, eating edibles at work. Isn't that what's going to happen? And the answer is definitively no. There's a second definitive answer from a lawyer in one presentation. We should probably call it a day. So the language that I have here on the screen, this was language that was in Amendment 2. it remains in the law now, and it is a very employer-friendly language. And so what it says is that a qualified patient or a consumer, regardless of type of user, cannot bring a claim against an employer for a variety of different things if the employer is prohibiting the employee from being under the influence of marijuana while at work, or disciplining the employee up to termination of employment for working or attempting to work while under the influence of marijuana. Each state has very different marijuana laws. What is permissible in each state is different. Some states prohibit pre-employment testing entirely. But one consistent thing is, across the nation, there is not a state that requires an employer to allow their employees to work while under the influence. That is one area in which we can analogize to alcohol. Okay? So I say be careful about making analogies to alcohol, but this is one in which we can make that analogy. We don't allow our employees to drink on the job. We wouldn't allow our employees to consume on the job. Okay? The other piece that is an employer-friendly language that remained from Amendment 2 is this language that talks about the section is not intended to allow for the public use of marijuana, driving while under the influence of marijuana, the use of marijuana in the workplace, use of marijuana under People 21. And then it goes on to talk about you as an employer are not required to permit, you can, you're not required to permit or accommodate conduct on your workplace or on your property. You're not required, you're not prohibited from disciplining an employee, et cetera, et cetera. So I say this in just, if you are a business owner, if you're wrestling with, what am I supposed to do? Do I have any authority as a business? The answer is yes, you do. I want to just pause for a second to say, I represent all types of businesses. I have clients of mine that think that marijuana is the absolute worst thing that has ever happened on the planet. I have other clients that are like, I don't care. Let's just stop testing for it entirely. Wherever you fit on that spectrum, there is a way in which we can approach this. So I just want to say that I'm not here to say it's good, bad, whatever. My husband calls me a perpetual fence rider, so that's where I am. All right, so let's talk about the qualified patient restrictions in Amendment 3. These are brand new things that are in Amendment 3 that were not previously there in Amendment 2, although Amendment 2 is about the qualified patient. So the qualified patient employment restrictions now say that if we have a medicinal user, an employer cannot make employment-related decisions and or discriminate against a person based upon their qualified patient status, if they have a valid ID card or if they're a caregiver. They cannot make employment decisions based upon the patient or the medicinal user's off-site legal use of marijuana during non-working hours, or for a positive drug test if a person has a valid qualifying patient card. Wow, that's pretty big. That's pretty big change. So what I have here in the red language, all laws have exceptions, right? And that's what we have down here in the red. So the protections listed up there for the medicinal user do not apply if the medicinal user tests positive for marijuana and used, possessed, or was under the influence on the premises of the place of employment during working hours. So you can be a qualified patient card holder, but if you used, possessed, or were under the influence and you test positive, your employer can still terminate your employment. It is not unlawful to do so. Okay? Those protections listed there don't apply under those circumstances. But wait, there's more. Some more exemptions. So those protections for the qualified patient are the baseline rule. Now there are other exceptions or exemptions for businesses that, if abiding by the rules would cause the company to lose money or a licensing-related benefit under federal law, there's no protection for that medicinal user. And so I have the example here of, think about DOT regs. Anybody that has Department of Transportation, which is federal law, or think about scenarios in which you might have government contracts, grants, things like that, in which you are receiving federal funds. Why can we not comply with Missouri law if we are subject to DOT regs or have to abide by the Drug-Free Workplace Act under federal law? Why?
It's not federally approved.
Because marijuana is still illegal under federal law, okay? So what this is saying is if your business, let's say you have truck drivers or you're subject to DOT regs, those individuals have to have periodic drug testing, they have to have periodic physicals, and if they test positive for marijuana, they cannot be on the road for you. So that is an example of an exemption and no protection in that business. Another exemption is for positions in which the legal use of marijuana affects the person's ability to perform job-related employment responsibilities or the safety of others. Hold that thought, because I still don't know what that means. Okay. Or it conflicts with a bona fide occupational qualification that is reasonably related to the person's employment. So a bona fide occupational qualification, oftentimes people think of, there are certain occupations like a pilot in which they can restrict the age of a pilot who is flying commercial flights, whereas in other occupations it would be unlawful to do that. You can't make decisions based upon someone's age, but if it is a bona fide occupational qualification. I think an example that we could use for marijuana purposes might be like a rehab program or something like that, in which we are rehabbing folks that have, that have marijuana-related rehab treatments and things like that. So I said hold on that second bullet point. So this is what the actual law said. This is what the language says. Yes?
Oh, I just had something back on that DOT. I'm the one, I work with the alcoholics and weed, and I get a lot of them from DOT, and it's not just driving trucks.
Right.
I get them for forklifts,
That's correct.
and no matter what's motorized. So I don't know who has forklifts out here, but if they're doing weed, they end up having to come do one through clearinghouse.
Yeah, it's going to depend. It's going to depend on the type of forklift operator that they are. Not all forklift operators are going to be subject to DOT regulations. Now, you may be getting employees who are on what lawyers call a last chance agreement, in which as a condition of continued employment, post a positive drug test, that they're required to go through a treatment program in order to keep their job. That might be something that you're dealing
Well, I
with.
find a lot of them from certain companies
Yeah.
that just don't want it, and others you
That's
don't
right.
even hear from them.
Yep.
I know they got forklifts. I just wanted to.
Yeah, but forklift driver, so when you're talking about DOT, we're talking about anyone that is traveling on public roadways. Forklift operators don't typically travel on public roadways. They're, maintained within a lot or a yard or within a warehouse or something like
They
that.
still go through the same system, is what I'm saying. They're still referred through the DOT
Okay,
thing.
okay,
I just wanted to
Yeah.
get that out.
Wouldn't a forklift operator potentially affect loading, which would affect safety on the road?
it could, but technically they're not covered under that. Your business might be covered under the Drug-Free Workplace Act because of those regulations. And that's where, in my checklist of things for you all your homework after today, is to go back and evaluate your business to figure out what must I comply with, what are the options that I can comply with, what choices remain to me as a business. So one of them is, do I have federal grants, contracts, subject to DOT regs, things like that? If that is the case, I have no choice but to follow those rules, and I cannot permit positive marijuana tests in employment, okay? So that's one area. If your business does not apply in that, or does not fall under that exemption, you have some choices to decide how you want to interpret, okay? So This is the second bullet point that was on that previous slide. I just want to read this language to you. It says, nothing in this subdivision shall apply, so these are the exemptions to the qualified patient protection, but that shall apply to an employee in a position in which legal use of a lawful marijuana product affects in any manner a person's ability to perform job-related employment responsibilities or the safety of others, et cetera, okay? In any, the lawful marijuana product affects in any manner. I have no idea what this means. Lawyers have been debating.
Vague, isn't it?
Lawyers have been debating about this since November and trying to say, what do we tell our clients? So what this is saying is, if you as a business can articulate that by having THC in your system, not you, but your employee, by having THC in the employee system, we're not talking about impairment, we're not talking about being under the influence, but if by testing positive, because we all know how marijuana works, right? You can consume marijuana on vacay in Colorado or just here. You can vacay here now. You could consume for recreational purposes. You could consume for medicinal purposes a week ago, 2 weeks ago, a month ago, and you could still test positive for THC a month later. So what this is saying is, if by having THC in your body, a positive marijuana test, if a business can articulate that the legal use, which is what we just described, affects in any manner a person's ability to perform job-related responsibilities, that employment protection does not apply. And so this is where a lot of businesses are wrestling with how strict or how lenient are we interpreting this. And as I sit here today, and I have talked with other attorneys in my office. We've had roundtable discussions about this. I've talked to other law firms. We're all in the same boat and saying, until the court weighs in, this is so broad, we can kind of do whatever we want. We can articulate that, by having THC in the system, it could impact somebody's ability to perform their job. It doesn't mean that it actually does. Where if I was looking in my Lauren crystal ball, I think that we're going to get clarification on this. I think that if you wanted to take the position, that your jobs, or like a forklift operator, for example, warehouse workers, anyone that has a safety component to their job, that you could articulate and argue, hey, having THC could impact somebody's ability to perform their job. I think over time that is going to be a losing argument. Because there is not a connection between, THC in your body from 30 days ago versus somebody that's impaired now. So a lot of my clients are saying, well, we need to evaluate the positions that we have. Are there positions that we want to take a strong stance and not permit the qualified patient or the recreational user if they test positive for marijuana or not? And that's something that you're going to have to wrestle with as a business if this is something that impacts you. So, so let's talk about drug and alcohol testing policies. So as I said before, at a minimum, your drug and alcohol testing policy has to be adjusted. Most policies have some type of language in it in which it defines what you mean by an illegal drug. Well, in Missouri, marijuana is not an illegal drug anymore. So if your policy says you prohibit illegal drugs, you've now excluded marijuana because it's not illegal. So you can define what you consider marijuana, or what you consider as drugs. I would take out the word illegal out of your policy. I would define what you mean by drugs, which you also need to include language for valid prescription drugs that are used for improper purposes. I will also clarify to you, marijuana for medicinal use is not a prescription. It is not a prescription. Why is it not a prescription? Because you do not get it at a licensed pharmacy. You get it at a dispensary, okay? So it does not fall under those same rules. Okay, so Amendment 3, keep in mind, it prohibits employers from making employment decisions based on the positive drug test for qualified patients if their positive test was due for lawful consumption off the employer's premises. That is, unless one of those exemptions applies to you. Okay? So what are the types of testing that we normally see? Pre-employment, post-accident, reasonable suspicion, random, periodic. Those are the types of drug testing. Somebody had mentioned about having, I'm over the term labor shortage, but we have to keep saying it. But people keep saying it's hard to get people in the door, right? So I have a lot of businesses saying, let's take a look at our pre-employment testing and make a modification there so we can bring people in, but retain some legal rights for testing if we have one of these other incidents. But those are the types of testing and what you need to evaluate in your policy about how you're going to move forward with it. So these are some testing options, and these are things that I've been seeing really since 2018, these types of changes to drug testing policy. So the first one is I have folks that say, I'm changing nothing. I'm changing nothing in my policy. I'm going to keep testing the same way that I have, but you can only do that if one of those exceptions apply, okay? So keep that in mind. If you presently test for marijuana, pre-employment, and in all of the other tests, and you have somebody that comes forward and says, I tested positive, or they tell you in advance, I'm going to test positive for marijuana because I have a qualified patient card or I've recreationally used, you have to be prepared on how you're going to answer that, okay? Kind of the other extreme, I've had some people just throw their hands up and say, I'm not testing anybody anymore on anything. Meth, bring it in, don't care. Just kidding, it's a joke, just a joke. But some people have just said, you know what, I'm gonna stop all drug testing. I have other businesses that are saying we're stopping all pre-employment testing. I'm gonna continue to test for all the possible things if I have an accident or reasonable suspicion, but I'm just gonna not test pre-employment. Another one is removing marijuana from all testing panels. Now, I think that this really depends on your business and your personal views, but I do have a lot of businesses that are working with their drug testing provider asking for the panel for marijuana or THC to be removed from their testing. They don't even want it reported on, they don't want it tested on, they don't want those results back to them. That is an option that you could do. I have had a few drug testing companies that say, it's a panel, we can't remove it, but you can ignore the results. As an attorney, I would prefer you just didn't know. Prefer you didn't get that on your report. If you don't want to know, you're not going to take any action on it. There's no reason for you to have it there. But understand that there might be limitations. The other option here is the remove marijuana from only pre-employment testing. I think I mentioned that before. That is probably the most common that I've seen is number 5, which is businesses saying, I'm going to continue to test for the real bad stuff, methamphetamines, use your imagination, okay? I'm going to continue to test for all of that. I'm no longer going to pre-employment test for marijuana, but I want to retain the right to test for marijuana post-accident, reasonable suspicion, primarily reasonable suspicion, because if you have the belief that someone is impaired, the law protects you from making that employment decision. But you also need the positive drug test to support that decision, okay? So that's probably the most common one that I'm seeing. And then number 6 is the test only specific occupations. That is completely legally permissible to do. And so I analogize it like, think about a warehouse environment. Most warehouses are, a big building, and there is a literal brick wall or cinder block wall between the warehouse and the office staff, right? And so a lot of folks will say, we're going to test everyone that's on the other side of the cinder block wall that have safety positions, forklift operators, truck drivers, whatever it is, but our office staff, we're not going to test anymore. That's completely permissible and legal to do as long as you're consistent within the categories of employment. I can't say, you all are office staff, he looks real suspicious. He looks real suspicious, and I'm going to test him. You don't. I was just joking. I told you I was going to call on you. Yeah.
I'm not guilty.
Yeah. So I can't just say you all are in the same occupation, the same group. I'm testing one, but not the rest of you. You can't do that. That's not permissible. Okay. So now let's transition a little bit from drug testing and talk about these expunged records. So this is where I was talking about a new change in Amendment 3 is that individuals that have those expunged records are not required to acknowledge the existence of such a criminal history or answer questions about the record in any application for employment, regardless, this is key, regardless of whether the person has received notice from the court that the expungement order has been issued. Ooh, that's risque, right? So what this means is, and how does this come up? It comes up in, you have an application, because you're outside of Casey Moe, you have an application that asks the criminal background question. Have you been convicted of a crime or felony? And somebody checks no. Then you run a background check on them. Well, guess what? On the background check, it says, yes, you did. So now that you have that, what do you do with that person? You assume that they are not truthful, right? You assume that they lied to you, they're not truthful, and so oftentimes businesses will resend offers to say, hey, this job was contingent on a successful completion of a background check. You were also dishonest. The application has information about it that says if you didn't provide truthful information, we could resend, yada, yada. So what I'm cautioning you is if you have that practice and you are doing background checks and something comes up related to a marijuana conviction, be very, very careful about taking any action if that person did not disclose it, okay? Be very careful. And also, if they do have a marijuana-related conviction, because we're going to continue to see these pop up on background checks until we get through this expungement process, okay? It's going to take a while, folks. It's going to take a while. So we might see things that otherwise we cannot use against that person because it could, in a month from now or 6 months, be expunged. All right? Okay, now let's get into some common questions. I mean, just marinate on some of these pictures. I mean, they're really fun. Really fun. Okay, are employees allowed to take weed breaks like smoke breaks? I can't make these questions up. My phone rings and these are the things that I get. What's the answer to this?
No.
No. See, you all are very good students. The answer is no. Again, this is similar to what I said about, analogizing with alcohol. Now, there are restrictions. Now, I've presented to enough chamber groups in which folks have started asking me questions about public consumption and what if I'm a business that operates in a public space, or I'm a restaurant or a bar or something like that. Can I prohibit the consumption? You're going to have to look at your local ordinances and what your local ordinance has permitted. So the law actually says you can only restrict the public use of cannabis in places in which tobacco is not permitted. I'm paraphrasing. So let's take Raytown, for example. They were wrestling with, because Raytown, you can publicly smoke in a lot of places. They were wrestling with, what do we do? Because we allow tobacco smoking in certain places. Can we lawfully restrict cannabis use or not? I don't actually know where they landed on that, but that was a topic that was being discussed. So keep that in mind. Okay, this guy's real happy. He's real happy. Can I prohibit employee possession of marijuana at my business? Because keep in mind, the law permits, it is lawful to possess cannabis products. As a business, can I prohibit possession of my employees? How many say yes? Yes. How many say no? No. How many of you didn't vote? Okay. So the answer is yeah, you certainly can restrict the possession of marijuana at your business. I always remind people of this, that you can, when you have your business, you can restrict things further than what the law allows. For example, you can tell your employees what they can and cannot wear at work, what the dress code is. You can tell employees what they can and cannot say at work. Like, it's lawful to make inappropriate jokes. It's lawful to do that, but I can prohibit it in my workplace. Same thing here. Oh, this one. What does it mean to be under the influence? I have been soliciting people for businesses since 2018, okay? No one has taken me up on this. I've been trying to invest. No one has taken me up. There is not currently a reliable test that we can use for testing impairment and influence, and under the influence. Now, there are lots of tests that are being beta tested. There are roadside tests that states like California and Colorado have been using to help with testing for drugged driving. But there is not a reliable test presently, like we have for alcohol, that we can say definitively, if we have a THC concentration of X, that equals impairment, okay? There is not such a thing. So, we have been wrestling with this since 2018. Like I said, I have tried to invest in businesses. Nobody's come to me. But where we are with this right now is if you have the belief that someone is impaired or under the influence on your job site or workplace or office, whatever you want to call it, you should be documenting by 2 supervisors what you saw that led you to that conclusion of impairment, okay? What did you see? What did you smell? What did you hear? Did they offer you some? I don't know. But what are the things that led you to, I believe that person is consuming or impaired on my job site? Because that's a conclusion, right? Sometimes, it's odor. Sometimes you see it. Sometimes you hear people talking about it. There are a variety of ways. But you want, if you have that belief, you want to have 2 supervisors go document what that looks like. Now, the question I always get after that, and maybe you're the expert, not me, but the question I always get after that is, what should I be looking for signs of impairment? Those are things that not everyone is familiar with. And there are certain things that you can look for, just behavior that is different than the person's normal behavior. Are they acting differently than usual? There are a variety of things that we can point to. Not any one of them are a definitive factor, oh, that person is definitely impaired by marijuana. So just keep that in mind and document that along with a drug test. If you have reasonable suspicion drug testing, there's tangible reasons that led you to that conclusion, a positive drug test, and then follow your policy based on that, okay? Can I test for marijuana impairment or influence? We just talked about that. If marijuana is still illegal under federal law, does that allow me to continue drug testing like my company always has? So the answer to that, this was the answer in 2018 was yes. You can keep doing what you want because it's still a Schedule I illegal substance under federal law. So the answer now is different. You cannot continue to test like you always have unless one of those exemptions applies, okay? If one of those exemptions do not apply to your business, then there is an additional step that you have to take. So typically in a drug testing scenario, you send an employee or a candidate for a drug test. They take the drug test and you either get back a positive, negative, or pending. If you get back a pending result, what that means is that the person has tested positive for something that is in the panel, and the MRO, or the medical review officer, is in communication with that individual to get information about whether or not they have a valid prescription, maybe for one of the substances they've tested positive for. So then, if that person is able to provide a valid prescription, then you get back a negative result. So that comes up in situations like opioids, things like Adderall, things like Xanax, those types of medications which are controlled substances. That person has to be able to provide a valid prescription that they're lawfully able to consume that. So let's assume that your business does not apply any of those exemptions. What we are wrestling with right now is whose responsibility is it to determine who is the qualified patient and who's not. My preference as business legal counsel is to push that to your MROs. Communicate with your drug testing company on what your policy is about marijuana. If you are treating marijuana in a qualified patient as a negative test, then you need to communicate that with your drug testing company to see if their MROs are doing that for you. If they're not, you have to figure out what you're going to do and how you will address that. I think pushing it to the medical providers is the appropriate thing to do, because you wouldn't normally collect prescriptions or a qualified patient card for your employees under other circumstances. Okay? Can I consider legal off-duty use of marijuana in connection with employee disciplinary issues? Where this comes up is you have employees bring you social media pictures. And they say, look at what such and such was doing on the weekend, right? And they're doing all kinds of things that you wish you can unsee, but you can't. And so what this puts you in a position, the law prohibits you as an employer for making decisions based on lawful consumption off duty. So if you have that employee that brings you that picture and you think, whew, okay, didn't need to see that, you cannot take employment action based upon lawful use of those products, okay? And I would caution you that if you say, I'll randomly test that person. Folks, that is not random, okay? That is not random at all. So be very cautious about doing so, because the law would prohibit you from doing that. Yes?
Real quick on that, when they talk about the off issues and they go, when you're talking about the employees, what I do outside of work is my business, it's legal. So if I smoke a fatty on the way to work, guess what? They're under the influence in work.
Oh, that's correct, 100%.
So it can't be just like somebody drunk at night at 2 a.m. goes to bed, they're still intoxicated in the morning. So there's still, that does apply
Right.
by that scenario. You can't just say I did it outside driving to work on my own time, it's legal. But
Right.
yet when they're in the building, they're under the influence.
Right. So in that scenario, you would, if your policy tests for reasonable suspicion, you would go through and document, somebody brought me this social media post, it was posted this morning, person was hotboxing in the car on the way here, they reek of marijuana. You would document those things, and then you would send them for a drug test, and you would confirm the impairment or influence. What I'm talking about is more of like, here's an old post
From the weekend.
from 2 weeks ago when they were on vacay. Look at how they're presenting themselves on social media. Now, what you said is also a common misconception, that employees believe that what they do on their personal social media, off duty, on their own device, their own time, personal page, don't mention the business, that they think that cannot get them in trouble at work. Go back to your office and Google ways in which I can get fired from Facebook posts, okay? And you'll get all kinds of stories. I actually do a social media training in which I have really great fun examples of pictures and things that employees have posted that have gotten them fired. They've tried to sue businesses and they lose because their conduct violated policy, and what ends up happening is the conduct then gets brought back into the workplace, and that's where the issue is. Okay? Yep.
I'm having, with this whole scenario, this little issue. The Constitution, federal Constitution states that the federal laws in general supersede state laws. So if you tested somebody, they can't come back and say, well, our state law says you can't test me. Federal law says you can. So where?
So what you're talking about are preemption laws. Preemption laws, which means that federal law preempts state law when there is a conflict. So what we're
Conflict.
So what we're trying to do is to balance state and federal law. If we were ever challenged that we took an employment action consistent with Missouri law, we didn't intentionally violate Missouri law, and that we took employment action and we're challenging the constitutionality of the Missouri law, we would make preemption arguments to say we complied with the law, but also federal law allows us to do so. In this context, we're not making those arguments. We're not just ignoring the Missouri law and intentionally violating law by saying, well, federal law says we can do something else because Missouri law says we can't. So think about like wage and hour, for example. So wage and hour laws, there are difference between state laws and federal laws. Minimum wage, for example. Missouri law has minimum wage at a higher level than federal law. And so the way in which the law works in that scenario is we have to abide by whichever law is in the better benefit of the employee. And so we pay the Missouri minimum wage. We can't just say, well, federal law allows us to pay $7.25 an hour. We can't do that. We would be in violation of the law for doing that. Similar thing here. We can't just say federal law is more strict, and so we're going to follow that. We have to abide by whichever one is in the benefit of the employee first. There are legal arguments, and like I said, a lot of this is going to get will get clarified once we have some litigation. I follow litigation trends, and since 2018, I've seen marijuana-related lawsuits, but they have more so been related to I got terminated from my job, like a DOT driver. I got terminated from my job because I was using a CBD. Lost train of that. I was using CBD oil or CBD products that advertised it was THC free. But then when I went and got drug tested, I tested positive for THC and lost my job. And so the lawsuits have been to the advertisement of a THC-free product. I have not seen employment litigation for businesses taking employment action since 2018. I actually just did a search yesterday, make sure nothing new had popped up, and we still have not seen anything. I suspect, just like other states have had many gap fillers in their laws, and I think that we're going to see that happen here in Missouri as well. Okay, I was in I think it was in Lee Summit Chamber, and somebody said that the Amendment 3 should be called the Lawyers Employment Act of 2022, because there's so many different, depending on what area you're looking at, whether it's ordinances, public smoking, et cetera, consumption, whatever, there's just so many gaps. Somebody described it to me as it really felt like Missouri took a different state's laws and that we tried to make it fit in Missouri, and it doesn't exactly make sense for the laws that we have in Missouri. So we as a collective group of lawyers are trying to unpack it and make sense of it. So, all right, next question. Should I ask for and keep a copy of an employee's qualified patient card? How many say yes? How many say no? How many of you are like, I came here so you gave me the answers. I didn't know I had to know these things.
If you're a lawyer, you're not going to give us any answers.
Hey, I've been giving all kinds of direct answers today.
Give them, you can understand.
So this is kind of a slippery slope. The law is telling us we have to treat qualified patients potentially different if we are doing drug testing. I revert back to, what do you get when you are asking somebody for a qualified patient card? Medical information. The law prohibits you from requesting or inquiring about medical information except in certain circumstances in the employment relationship. So although marijuana, a qualified patient, is not a prescription, it is a recommendation from a physician to treat a medical condition, which is the definition of a prescription. But it's the recommendation. We don't go to our employees and say, I need a copy of your heart medication prescription. I would like a copy of your birth control prescription. I mean, we're all like, that sounds ridiculous. We would never. Same thing here. I don't want to see people keeping photocopies of that. What happens in the employment context is that you have applicants that come in and just disclose. I'm a qualified patient. Is this going to be a problem? Do you drug test? Is this going to be a problem? And my advice to you is to know your policy. So refer back to your company's policy to say, our company does drug testing on these scenarios, and we do consider cannabis, marijuana within those panels or we don't. So know your policy and know what you're doing. And that's what you can refer back to when those folks ask you those questions. Okay, another question. Can employees possess marijuana in their car on company property? How many say yes? How many say no? Y'all are like, tell us the answer. So this one is a little bit tricky. So from a business and practical perspective, no one is in the business of searching your employees' cars, right? I mean, personally, I would not want that job, but no one is in that business. However, the law does allow you to restrict possession on the premises of employment or the workplace. So you could contain or put that language in your policy to say, we do not permit possession on the company property or premises. You could put that language in there. You're not going to go out and enforce it and check someone's vehicles, but if it became an issue and you had reason, like somebody was consuming or smoking and you could smell it and they had their door open, you could ask to see inside of their vehicle, and it could violate your policy. So that's up to you on whether or not you want to go that route, but it is permissible.
Didn't you have a slide before that said, can they bring it to work? Was there a similar slide like that before?
Possession at work.
It's on the person.
Right. So we're talking about on their person and walking it in their pocket or their purse versus leaving it out in your parking lot on your property. That's the difference in that question. Okay? So the answer to that is make sure that it is addressed in your policy. Like I said, you're not going to, as people drive on your lot, you're not doing searches. At least I hope not. I mean, that seems kind of like a waste of time. But what do I know? I'm just a lawyer. So what if an employee tests positive for THC and they are not a qualified patient? What can I do? So if you remember, two different types of users, two different sets of rules. As an employer, there is no employment protection for the recreational user. Okay? Recreational user, if they are not a qualified patient, there are none of those restrictions on what you can and cannot do. So refer back to, remember that advertisement I showed you at the beginning, that people are getting wise and saying, hey, if I choose to consume or use cannabis, whether it's for personal use or medicinal use, if I have a card, I now know that that has certain job protections. That's what that advertisement is saying. I think I already answered this one. Can I terminate or rescind a job offer to an employee for not disclosing a marijuana conviction on an application or during the interview process? The answer to that is depends upon the type of conviction, if it's a violent crime, but if you are going to do that, seek legal counsel. Because what you don't want to do is to inadvertently break the law by making or rescinding that if that conviction was one that is eligible for expungement. Okay? Yes?
Would you be able to still do that with the adverse action, the adverse action letters?
Well, that would be part of that process, but it doesn't, a pre-adverse action and adverse action letter says, hey, something came up on your background, we need to discuss it with you. I'm saying to be careful about addressing it at all. That if you have someone that has a marijuana conviction, that is not, if it's just possession only, intent to distribute, something like that, that is not a violent connection crime, there is a chance that that is going to be expunged. So be very careful about making any employment decisions based upon a background check for a marijuana conviction, because that is something that they're not required to disclose to you. Okay? Okay, an employee reported to me that they think their coworker is high. What do I do? Now, some people say, well, I'd just go fire the person. And I say, here's my card. Okay. So in this scenario, I will warn you, you all know this, but not all people have good intentions, right? So we're talking coworker to coworker. Some coworkers are trying to get somebody in trouble. So if somebody reports to you, hey, I think that such and such is high, you're going to ask them questions. What led you to the conclusion that that person is high? What did you see, smell, hear, taste, whatever? You ask them those types of questions. Then, if they are able to provide enough information to you, you should send a supervisor out to go observe, can they confirm what this employee is saying? Then from there, you would follow your policy, whether or not you have reasonable suspicion drug testing or not. Okay? How does my drug and alcohol policy impact workers' compensation benefits? So, presently, in the state of Missouri, you as a business can take a reduction in work comp benefits if somebody tests positive for a drug and that positive drug test relates to or contributed to the accident or injury. You can take reductions of 50% up to 100% of benefits if the person was impaired or the drug was the contributing factor to the drug or substance to the accident or injury. But only if you have that language in your employee handbook, in your drug testing policy. You cannot take the reduction if it is not listed in your employee policy. So, make sure, this is another kind of plug for looking at your drug testing policy. Make sure that it has that language in there. The other piece about, well, what if somebody tests positive for cannabis or THC and we have a work-related injury? We still have to be able to make the connection that the THC and the impairment were related, and then that is related to the accident itself. So this is something, work with your work comp provider on what they are requiring and what type of reduction that they're doing, but it will be harder to take reductions for cannabis-related cannabis-related positive drug tests without the attachment of signs of impairment. Okay.
On that. So if there's no way to really prove they were impaired while at work from the THC, I mean, other than documentation of observing, the smelling and taste, what is there a way to prove that they actually were?
So that is what we would legally rely upon, is that there was objective evidence of impairment plus a positive drug test plus your drug testing policy, and then you make your employment decisions consistent with that. Also, some people just admit it. And they say, yeah, I smoked on my way here. I think he said smoked a fatty or something. So that's there. Now, I will tell you, other states have gotten more sophisticated in this area. Colorado recently, a year or two ago, came out with levels of concentration that said if someone tests positive for THC and the concentration level is X range to Y range or whatever, there is a rebuttable presumption that the person is impaired based upon the concentration level. And so that is helping law enforcement with drug driving and things like that. Missouri's law does not say that. So I suspect that over time we're going to get some more clarity on that so that, to your point, we would have more definitive answers about impairment or not. Okay?
Nanograms, level act will determine it, because I know Colorado, when it first started, their DUIOD, which is under the influence, was like 5 nanograms. If there's 5 nanograms in their system, they're going to get one, and they can do that by blood. They just have no way of, I think Colorado's testing out the swabs for active THC, but it's not.
Yeah.
That's not a good
way
of doing it at the present moment.
Yeah, there's arguments about unlawful search and seizure inside somebody's mouth on the side of the road, so there are issues with that.
That's all the issues.
Yeah.
But there is a level that you could see if they go in and they're 400
Yep.
nanograms in their system, guess what, they're high.
Right. So what about marijuana DUI, DWIs? If you are a business that requires your employees drive and you have insurability requirements, make sure that your policy has language in there about requiring employees to report DUI or DWI convictions, because drugged driving also falls under DUI, DWI rules. Okay? So I'll wrap it up with this. Here's your 5-step plan or homework after you leave here. Go back to your place of employment and evaluate your current drug testing policies and practices. Once you have reviewed what they currently say, you need to make revisions to your handbook and drug testing policies. Make sure that it's consistent with current Missouri law. Also, if you have businesses in other states, make sure that you are not inadvertently violating the law. Like Nevada, you can't pre-employment test for marijuana at all. So that's just an example. So make sure that you, when you are doing this review, determine if one of your business or positions within your business could qualify for one of the exemptions to the qualified patient protections. I say if they qualify or if you must qualify for one of those exemptions. Think of like the DOT that we talked about. Step 4, train your HR professionals, managers, and supervisors for those conversations with employees or applicants regarding medical marijuana and personal use, and then also train managers on the signs of impairment at work and how you address working under the influence of cannabis. Okay? Yes?
Do any of the laws that protect the people with the medicinal cards roll over to if they live in and are residents of Missouri and they work in Kansas? Are they protected at all?
So from an employment perspective, it is the laws of the state in which they are employed. So if they live in Missouri, work in Kansas, Kansas is one of the last 4, 5 states in which there is no legalization of marijuana at all. So it would be unlawful in the state of Kansas. Interestingly, our Missouri sales have been very high, pun intended. But part of the reason is that folks can come from Kansas and other states to purchase in Missouri, and that is permissible. If they cross state lines and get caught with it, it could be a felony. Interstate transport of drugs. So anyway, any other questions, comments, or sarcastic remarks? I will only take them for a few minutes. Yes.
I have a small company, so it's just me, but I work with a lot of probation and parole and municipal courts, and they have to stay separate. So I'm here kind of learning so I can help my clients who are trying to get jobs and say they can't because I got marijuana in the system, they won't hire me. They won't hire me because I got a marijuana conviction. That's what I'm here to learn. But I struggle with, and I want to know you as a lawyer, if you've had problems with probation and parole people are held by federal. They don't matter medical card or not, you don't smoke weed.
Yep.
And they're sitting in a group with municipal people, independents, police, some, all them. Yeah, I smoked a joint yesterday, because guess what, they can't. I can't do anything about it, I won't, I mean, it's legal. But he's sitting next to a guy that goes, that ain't right, because I don't get to. Have you had, because I've had a lot of letters from lawyers coming after me, going, you can't put him in treatment for weed on probation and parole. It states right in it.
Yeah.
But yet, according to
Yeah.
probation, state probation parole says it doesn't matter, we're federal, we
Right.
will not allow it.
So that is outside my practice
Okay.
area, so
I didn't
that
know if
falls
that's
more
something
into
you
the
have ever
criminal
dealt with.
side. But in communicating with folks that are trying to obtain jobs, you just have to have those candid conversations to say, if it is something that you are continuing, that you are going to continue to use cannabis products, then maybe you need to be forthcoming in the interview process, or maybe you need to be looking for postings, or just asking the question of what is the company's policy on drug testing. There's nothing improper about asking that question, but know that there are that those exemptions may or may not apply. And so people have this belief that, well, because it's legal, employers can't do anything about it because it's recreationally legal. That is not true. Not true.
Thank you.
Yep.
I heard something on the news, local news recently with reference to driving while impaired, and that the police or highway patrol or whatever have some kind of a test that they can get an immediate reading on. Do you know anything about that?
I am not familiar with that. I mean, there are a plethora of tests that are being tested across the country, and so whether or not they're able to test the person or the vehicle, I don't know what they're using. But I will tell you that the Missouri law also prohibits the use of cannabis products while the vehicle is in motion. So that means passengers too. So if folks are, if somebody is driving, that obviously is not permissible, but the passengers as well are not permitted while the vehicle is in motion. That's what the law says anyway. Mhm. I think it's on page approximately 15 or so of the law. 17 maybe, I don't know, lost track. Yes?
At the beginning, you mentioned real briefly about like a restaurant with a smoking section,
I'm sorry, what?
like a restaurant with a smoking
Oh.
section, or say they can smoke on their patio, but they don't want people smoking cannabis. What can they do?
You need to look at your local ordinance on that, because what the law specifically says is that you can only restrict cannabis in the same places in which you restrict tobacco. So if you say no smoking or vaping in this area, it includes everything. So that's where the local municipalities have been evaluating where are they, what is their stance on that, and as a business, can you prohibit smoking cannabis or not? Because there are a lot of businesses that say that smells awful, and my patrons don't want to smell that, and so they're trying to restrict it. But you have to be careful. If you allow tobacco, you may not be able to prohibit the smoking.
No smoking period, can they say that?
Yeah. If it's a no smoking entirely.
Problem is, say it's a patio
Mhm.
that is allowing smoking, and he wants to know if you can say no smoking cannabis, or you can't. Smoking is smoking.
Right, so look at your local municipality of where you are located to see where they landed on that. Because the law actually says they were leaving it to the municipalities to make those determinations about public consumption in certain restricted areas.